Latin terms. By Olivia Homan. A writ of mandamus means in command or mandate. A mandamus is a judicial act in which a formal decision from a superior court is sent to a government or subordinate court and must either be done or is forbidden from doing some specific act in which that body is obliged under law to refrain from doing. For example, if a court in California does not uphold the decision of a Nevada court concerning the custody of a couple's children, a petition for a writ of mandamus can be submitted, explaining the importance of the previous decision in order to make the California court uphold the Nevada court decision. In simple terms, a writ of mandamus is used to make another court uphold another court's decision. A writ of mandamus must be titled in re name of petitioner. When submitted to the court, the petition must state the following: the relief sought, what the petitioner is asking for, the issue presented, the facts necessary to understand the issue presented by the petition, details concerning the case, the reasons why the writ should be issued, the importance of the previous court decision to be upheld. A writ of mandamus is typically written by the lawyer. A writ of certiorari means to be shown, referring to a type of writ seeking judicial review. A writ of certiorari means an order by a higher court directing a lower court to send the record of a given case for review. These records include all documents concerning the case at hand. This could be as much as a box or boxes of papers, all of which must go to the court to issue the writ of certiorari. For example, once the Supreme Court decides what cases it is going to entertain, using the rule of 4 in which 4 justices decide that the case is important enough to entertain and is believed to violate the Constitution in some way, the Supreme Court issues a writ of certiorari to the lower court in which the case was appealed from to receive all records of the case to review. The number of writ of certiorari coming from the Supreme Court is relatively low, because out of the thousands of appeals the Supreme Court receives and reviews, they only entertain about 1% of them. The Supreme Court is only concerned with cases that involve violating someone's constitutional rights. Amicus Curiae is when those interested in a case, but are not formal witnesses, submit briefs raising a different point of view and presenting information that they hope will influence the court's decision in their favor. Amicus Curiae briefs are one-way interest groups influence policy because they provide evidence in hopes to persuade the court in their favor. For example, the National Rifle Association would submit an amicus curiae brief to a court in an attempt to influence the decision of the court on an issue concerning gun rights. This brief could contain anything from the statistics of a certain rifle or the precautions that were made when manufacturing the rifle to ensure that it was safe. De facto is used to describe something that happens by fact, the norms within a society. For example, de facto segregation is segregation that results from factors like housing patterns rather than law. In the 1950s and early 1960s, African American communities were restricted to ghettos because of de facto segregation. De jure is something that occurs by law, meaning that because of a law passed, something happens as a result. For example, de jure segregation is segregation that is a result of a law passed by the government. For example, Jim Crow laws in the South. This was where by law there was separate seating for blacks and white in restaurants and buses. These were also the laws that restricted African Americans from voting. The map represents what African Americans faced in the 1950s and early 1960s concerning segregation. African Americans faced de jure segregation in the South, where they had to change laws. This was where nonviolent protests saw success. Whereas in the North, African Americans saw de facto segregation, where they now had to change society because they were no longer limited by law but by beliefs of others. Once African Americans overcame de jure segregation, they focused on overcoming de facto segregation, where America saw the rise of the Black Power movement, where Malcolm X became a strong advocate and voice for African Americans, and the Black Panthers saw success and popularity. This was where the violence on both sides began. Decisis is the legal principle in which judges are obligated to follow the precedents set in prior decisions. Stare decisis is extremely important because it ensures that decisions are uniformed throughout history, although the court could potentially make a new ruling on an issue and overturn the precedent set by a previous case. Today, if a case was to come to the Supreme Court and has to do with segregation, the justices would use the precedent set by Brown versus the Board of Education to make an informative decision based on precedents. Ex post facto is punishing someone for something that is now illegal but was legal when the crime was committed. On a side note, Congress is prohibited from enacting this type of legislation. For example, if Bob picked flowers from a national forest 2 months ago but the national forest only announced that picking flowers was illegal a month ago, Bob cannot be persecuted for his crime. In simple terms, if the act was not illegal when it was done, that the person cannot be prosecuted for their action because when it was done it was legal. Here are the sources I used.